let's talk about arraignment and your role as a defense counsel in courts. Before I delve into that, what does arraignment mean? Arraignment is the formal reading of a charge to an accused person, for the accused person to be informed of the reason why the person is being brought before the courts, and for that accused person to make a plea. Plea could be yes, I'm guilty, no, I am not guilty. The plea of acquit, that is, he has been formally charged, tried, and acquitted on that subject matter, on the course of action, okay? Or plea of pardon, that is, he has been pardoned on that offense. You need to understand that when an accused person is being brought before the court, such person must be unfettered, that is, that person must be unrestricted, no chains, the anchor of the chains must have been, the prison people must have removed all of those things from him. That is, he's still innocent until the contrary is being proven. Although, while conveying them probably to the correctional center, formerly known as the prison, you might see them being chained and all of those things. That is just to make sure that they don't run away. But when they are being brought formally before the court, it is very paramount that an accused person is being unfettered. It is also important that the accused person understands the language of the court, which is English. In a situation whereby the accused person does not understand English, an interpreter must be offered to the accused person. It is also important that the accused person take his plea by himself. Also, if there are several accused persons, each and every one of them must take their plea separately. That is, in a situation whereby there are 5 accused persons, just one person cannot take a plea on behalf of the others. No, each and every one of them must take a plea of either of those 4 pleas I mentioned earlier. So let's talk about it. As the defense counsel, what is your role in court on the day of arraignment? The important thing is that you need to be in court early. Peradventure, you have been able to meet with your client, the accused person, probably days before the day of arraignment. It will be good. So you need to coach the accused person as to his plea, how to take his plea, okay? Also coach the accused person how to address the courts, my lord, and if it is a magistrate court, your worship, coach the accused person not to use the word and things like that, okay? So coach the accused person on how to take the plea. If you are going on a route of a plea bargain, you know the accused person will be pleading guilty. If you know that the route you are going through is a full trial, that is, you know that your client does not have a case to answer, you want the prosecution to prove his guilt, the prosecution to prove the case beyond reasonable doubt, then you will know that the accused person is to take a plea of not guilty, and the plea of pardon, whether the plea of pardon is applicable to you or the plea of acquit, okay? So coach the witness. This is very paramount, okay? Because you cannot take an excuse from the court for you to approach the accused person while he is in the dock about to take his plea on what to say. I realize some people make this mistake, oftentimes forget, probably because they get to the court late, and probably matter has started and things like that. They may not remember to inform the accused person as to what to say when the charge is being read to him. And particularly if you know your client does not understand English, which is the language of the court, so he needs to really understand what is being read to him. So all of this information you need to know. If your client does not understand English, have that fact, so that when it's being asked, you as a counsel can also make the court to understand that the question being thrown at the accused person, it does not understand, and apply for the court to provide, or the prosecution apply to the court to provide an interpreter for the accused person. So your role basically is that coach the accused person, your client. Let me just use the word your client. Coach your client on how to take his plea, how to address the courts, and when the charge is being read and your client take his plea, make sure you apply to the court that the prosecution should be ordered, if they have not done that, to be ordered to serve on you the charge and the proof of evidence. Oftentimes before that day, the charge must have been served on you. Probably the proof of evidence is what you don't have. So let it be on record that you make an application for that the prosecution should serve you the charge and the proof of evidence, okay? Since the investigation has been concluded and the person has been arraigned, definitely there must be proof of evidence. So apply to the court for the prosecution to serve that on you. Importantly, ahead of that day, it is possible that you have filed your application for bail, okay, particularly in offenses that are not capital offenses. So make sure before the prosecution approach or apply to the court for a date for hearing, as a defense counsel, your third role is to move that bail application. I have series of videos on my YouTube channel about how to move a motion. A bail application is being brought before the courts by way of motion, okay? So I also have a particular video that's I spoke extensively on how to move an application for bail in the Nigerian courts. However, if you are unable to file an application for bail before that day of arraignment, I also have a video on my YouTube channel, particularly if you are before a high court, because we all have this opinion that any application you need to bring, particularly in a criminal matter, that you need to bring before the court, we all have this, many of us have this, or we used to have this understanding that it has to be by way of motion, it has to be formal. Okay, it is not so bad. But I have a video on my YouTube channel where I discussed about it, that it's only in civil cases that application must be made or shall be made by a motion. There is no authority that says application for bail, in criminal matters, must be formal. That is, you need to prepare a motion and file and serve another party. There is no authority like that. There is actually a judicial authority that spoke to that light. That I'll put the link of that video in the description box so that you can see what I'm talking about. So what I'm saying in essence is that if you're unable to file a motion for bail in a high court before the day of arraignment, you can still proceed and make an application, an oral application for bail, even though you are before a high court. So go through that video. The link will be in the description box so that you can see the authority I'm talking about for you to make an application to the court for your client's bail, even though you don't have a formal application before the court, okay? Many of the judges are aware, just the prosecution and some of the defense counsel, that we are not so much like myself. Before I came across that authority too, oftentimes you see defense counsel even will be the one to apply to the court for a short date in order for us to go and file a motion for bail. However, you can make your first attempt, except of course when the courts deny that application and make you to understand that you need to come formally, except until that time. So the court have the right to make a demand for a formal application, but that does not mean you cannot make the attempt first for an oral application or oral submission to get your client on bail. That's basically all I have for you in this video. Please subscribe, share this video. If you have any question, please drop it in the comment section, or you send it via my email address. My email address will be in the description box. Thank you so much for watching, and I will see you in my next one. Bye.